Welcome back to our latest Political Pulse. I'm Randy Aldridge, and I'm here with North Carolina Medical Society CEO Chip Baggett. Good to talk to you again.
Good to talk to you.
We're going to talk about something today that I think makes sense, but I think it's more complicated than I understand. It's called the No Surprises Act.
Yes.
Let's start with like a history, a background about what it is and what's happened so far.
So this is federal legislation that came out of Congress about a year ago that would actually provide protections for patients to know about their bills before they receive them in the mail.
On the surface, this seems smart and like something you can't believe
Yes.
isn't already happening,
Right.
but we've all been there. You have a medical procedure, you go to the doctor, and the bill comes, and you don't understand any of it. So this is to help that, correct?
It is. And to your point, we had a great solution in North Carolina already working, but the federal legislation took care of places where the North Carolina law did not impact.
And the Medical Society actually has been really involved in this.
Yes, from the very beginning. So we were involved both at the state level when we created that legislation. We were involved with the federal legislation to get a resolution that found a happy medium, that made sure that the patients received this notice and they understood what they were receiving, but also gave a balanced approach during the dispute process to make sure that our members were not disadvantaged.
So something big happened with this on
Yeah.
Friday. So explain to me what happened Friday versus what we've been talking about.
Right. So the legislation passed a year ago. Mm-hmm. And right after that, interim final rules came out from the agencies at the federal level. And those rules were in contradiction to the law that passed. So we jumped on and helped out with 2 lawsuits, one by the AMA, one by the Texas Medical Association. We also filed comment objecting to the interim final rule because it advantaged insurers much more so than the doctors during the dispute process. And on Friday, to your point, the final rule was adopted based on the outcome of a successful case with Texas and comments that came in from North Carolina and a whole bunch of other states that actually fixed the problem that we pointed out.
So are we talking about a win-win here?
Yeah, it's a win-win in the sense that patients have a much better sense now of what they're owed, much less likely to be surprised, right? Mm-hmm. And the doctors have a fairer process in the arbitration process. They still carry a huge administrative burden from this process, which I know that many of our members are discouraged by.
So, okay, in that case, the question is what's next? What can patients and physicians and providers expect next?
Yeah. So I think we will continue to work on trying to make this arbitration process as smooth as possible. One of the things that we're trying to work on is bundling arbitration together instead of having to do each individual piece. Another thing is that we're trying to make sure that insurers don't use this to try to manipulate contracts at the state level. We've already seen a number of insurers try to go for a lesser in-network rate in order to drive down these prices for out-of-network.
All right, well, I'm guessing we're going to hear a lot more about this.
Yes, this is going to be ongoing for a long time.
All right, great. Well, you can find out more on our website, ncmedsoc.org, and we'll be talking about this again. Thank you very much, Chip.
Thank you.